Okay, protected speech. The big Supreme Court case here that allows um, newspaper publishers and magazine publishers, internet publishers to publish almost anything was New York Times versus the United States. This was the whole Pentagon Papers case where I think I mentioned about the U.S. government conducting its own internal study that said basically the Vietnam War was unwinnable, the way it was going to be, uh, the way it was being run by the Johnson administration. New York Times got a hold of these newspapers from Daniel Ellsberg and published them. The Nixon administration went to court to try and block it, and the Supreme Court said nope. Even though they were secret, they did not violate any kind of national security issues, so they can be published. And again, national security was used particularly by Richard Nixon to kind of prevent things from happening. First Amendment, symbolic speech. We talked about the Stromberg case very briefly. I don't think you'll see this one about flying a red flag back in the 30s. Tinker versus Des Moines, of course, I think you might definitely see that on the AP exam, the wearing of the black armbands. The famous quote from Tinker was, "Your First Amendment rights do not end at the schoolhouse door." So, speech that non-oral speech, non-communicative speech is allowed as a protest as long as it does not cause a serious disruption in the school day. And then we talked about the flag burning cases in Texas and the controversies that had started in the 1988 1992 presidential elections. Flag burning is a protected speech. RAV versus the city of St. Paul, cross burning. We talked about that is a protected speech that you can burn a cross. However, some of these cities really should have went after the perpetrators for violating an open flame ordinance rather than a freedom of speech ordinance. Some of these civil rights can be curtailed by using other laws, like I said, like open container, open flame violations, rather than charging them with, desecration of a cross or the flag. Um, some places have created free speech zones. Uh, you see those more in the international protests when the G7, G8, G20 countries get together. Hyde Park Corner is a famous example in London. Um, the ACLU has an issue with them, but I mean it still is a spot for freedom of speech. Libel, slander, New York Times versus Sullivan. Remember, slander starts with an S. It's spoken. Libel is written. Call somebody's reputation into disrepute, defames your character. New York Times versus Sullivan pretty much made it very difficult for anybody to win a libel or slander case because you have to prove that the newspaper or the other person had intentions of committing actual malice and knowledge of a falsity and reckless disregard for the truth. Extremely, extremely difficult to prove libel or slander. Fighting words. Again, we talked about Chaplinsky versus New Hampshire. Um, Jehovah's Witnesses got in trouble for not pledging to the flag. Um, Lewd and obscene, the profane, libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace. Again, you have to look at the year 1942. The conviction of these people was upheld. And again, I remind you of the New York, Minersville School District versus Gobitis, which also said that people had to salute the flag. That was overturned just a couple of years later. We talked about obscenity, Roth versus U.S. Pretty much the Supreme Court left obscenity up to the local municipalities. The famous phrase, "I know it when I see it," really, it doesn't have any legal bearing, but again, utterly without redeeming social importance. And the average person, again, applying contemporary community standards, would find something obscene. That pretty much leaves it to the local municipalities. We talked about the internet, and Congress got involved in the internet because it is without borders. We talked about Communications Decency Act and the Child Online Protection Act were both overturned by the Supreme Court in Reno and Ashcroft because the law was too vague. It blocked too many things. So finally, Congress passed SIPA, the Children's Internet Protection Act, which has been in force for about the last 10 years, which limits things that can be presented on school and library computers, also requires every single school and library receiving federal funds, which is almost 100% of us, to have a SIPA filter, and we talked about that in class. We said DeJong versus Oregon allowed communists to get together. Again, the first Red Scare in the 30s, as opposed to the other one that would happen 10, 20 years in the future in the 50s. The right to keep and bear arms, again, one of our most controversial civil rights. The court only really mentioned anything directly about the right to bear arms in U.S. versus Miller. It's the last time the court directly addressed the Second Amendment. Miller was pretty much a gangster. It asked, the National Firearms Act asked people, not asked, but told people to register their firearms. Miller was convicted of not registering his firearms. The lower court in Chicago said basically it's unconstitutional. Supreme Court said no, it's okay, but we need another trial. Miller was not represented at the Supreme Court. No one took his side, so the government really had the case all to itself. I don't think something like that would happen today. And in irony of irony, Miller never got his second trial because he was shot to death. We talked about the Brady Bill, ban on assault weapons, and we talked about Toomey and Manchin and the bill that just did not pass the Senate. Due process, the right of anybody, and we talked about what due process means, to go through a particular set of rules, regulations, and procedures to be certain that justice is being applied to them equally and fairly. And again, 14th Amendment, due process, harkens back to the 5th Amendment. We started talking about the various amendments. We mentioned the 4th Amendment, illegal searches and seizures. You are protected from having the police use those items gained illegally in an illegal search against you in a trial. Again, if something is in plain sight, they can use it. People, you have to announce that this is the police. Again, remember the differences I gave you between a school and a police department. Schools only need reasonable suspicion, which the law has designated as 51% of surety that something illegal is happening or is in possession of someone, where the police need probable cause, which has been identified as 90%. 4th Amendment also goes into drug testing, and we talked about the Chandler versus Miller case, where public officials were told they had to get a drug test before appearing on the ballot. And it went all the way up to the Supreme Court, and the Supreme Court said, nope, you don't have to do it. Fifth Amendment, protection against self-incrimination and double jeopardy. The most famous Fifth Amendment case was Miranda versus Arizona. Miranda was not informed of his constitutional rights. Therefore, he sent a letter, asked for a new trial, went all the way up to the Supreme Court. Supreme Court said, basically, criminal defendants have to be read their rights, and they have to be able to understand them before anything that they say can be used against them in a court of law, and that they're also entitled to an attorney. This gave rise to Miranda rights, or Mirandizing suspects. Exclusionary rule refers to the fact that the government cannot use illegally gained evidence in a court of law against a criminal defendant. Weeks versus U.S., I told you, really don't worry about that one. Mapp versus Ohio. This is the one where the police got a tip that a woman had bomb-making materials and drugs in her house and was, creating bombs. The police went in, didn't have a search warrant. She threw them out. They came back with a piece of paper. She grabbed the piece of paper, put it down her dress, and then the police got it back, and they didn't find any bomb-making materials or drugs. They just found a box of pornography and arrested her for possession of pornography. Case went all the way up to the Supreme Court, and they threw it out. Gideon versus Wainwright, you have the right to an attorney even in the most minor criminal offense. We watched excerpts of this case